Thank you for tuning in. It's not often that I get to speak to a bunch of prosecutors about criminal lawyers' view of some of the case law, but it is somewhat an interesting area, and I think given the fact that municipal courts deal with a lot of traffic stops or automobile stops, hopefully you find some of the information relevant. The other thing that I've learned over the years, ever since you leave law school, most of us who are in private practice don't really get to deal, so to speak, with the law and interpreting, Supreme Court cases as well as Missouri Supreme Court cases and the different districts within our courts are in our state. So I put this presentation together. I am reminding you that some of this, most likely a lot of it, is from a criminal defense lawyer perspective. So take that in mind in the sense of how some of this is being analyzed, but also I'm going to try to present it in a way that takes the bias out of it, but mainly looks at the law. So the topic obviously today is Missouri automobile stops, and I thought it more than appropriate. Hi, I'm from the government and I'm here to help. So please feel free to ask questions, and I'm okay. I'd like this to be more of a kind of a working seminar in the sense of interaction. Feel free, if you disagree with my interpretation, feel free to point that out. I do think that the cases that are coming down are somewhat complexing as far as the legal issues as we go forward in our state and analyze traffic stops. So go ahead, Garrett, if you can pull up the PowerPoint. From what I understand, you can see me and the PowerPoint's a little bigger. I just can't see the camera. So the areas that to orientate you this afternoon is we're dealing with automobile stops, and we're taking a look at the law and to kind of shape the pigeonholes, if you will, is kind of what is the basis of the three areas of dealing with the stop of the automobile, pre-arrest searches, and then post-arrest searches. Because depending on how you analyze the law, I think leads you to different analysis that are coming out of the courts. And so, obviously when you're dealing with the stop, you look at what was the reasoning for the officer pulling the person over. Was there reasonable suspicion? Was there probable cause for a stop? Now, I will tell you on the front end, we learn these standards of law in the sense of, there's reasonable suspicion, there's probable cause, and then you move up the category of probability ultimately to get to proof beyond a reasonable doubt. What's becoming more complexing is the fact that I think our courts are starting to bleed or mirror the concept of reasonable suspicion with that of probable cause. And it's getting even more confusing as you read Supreme Court cases from the United States with the cases that are coming out of our state courts. And so I'm wanting to bring that to your attention and to take a look at it, because it's oftentimes if you're reading these cases, and for those of you who've done automobile cases or dealt with Department of Revenue cases, a lot of our law that has been shaped in the state of Missouri comes from either its DOR cases or DWI cases. That's been the development of our law in our state when it comes to automobile stops. And ironically, at the national level, where you're dealing with search and seizure issues, it's not necessarily a DWI stop that leads. It's other issues. It's more of a reasonable suspicion, or for that lack of a matter, not even probable cause. So you're focusing on the stop. Then obviously, once you have the stop, the officer is confronted with the situation, all right, pre-arrest search and basically pre-arrest conversation. The law is expanded in what I would tell you that officers, prior to custodial investigations, statements made by the suspect or the individual or lack thereof, meaning silence, can now be used against that. And a lot of times law enforcement has these tools out there that I don't really think that they know that they have, and it's given them great leeway in not only Supreme Court law, but law within our state. So obviously, as they're interacting with the suspect, then we get to the category of, does the officer have probable cause for the search? Issues such as, was there consent? Then, of course, the age-old question, how far does that consent go, or how far does the probable cause go to search not only compartments of a vehicle, but containers within the vehicle, so to speak. So we'll talk a little bit about that. And then lastly, we've got what I would refer to as the post-arrest search. Now you've got this individual out of the car. They're usually back in law enforcement's car. Again, we've got statements that are made now post-Miranda. We've got search incident to arrest issues. And then we have, obviously, inventory searches. And so, these are the kind of the three categories when it comes to automobile stops that I think to orientate you today in this presentation. Now, my name's Joe Passanisi, and my partner, Scott Pearson, unfortunately, is not here to share in this discussion with you. He had to run to court on an issue. But Scott and I have talked on this particular issue a number of times, not only to the Missouri Bar, but also Missouri Association of Criminal Defense Lawyers, and now the Prosecutors Association, because believe it or not, I think that the Fourth Amendment, when it comes to automobiles, pretty much doesn't apply. There is really no expectation of privacy when it comes to an automobile and an individual. And it doesn't take very much to stop, to search, and to question. And so law enforcement, believe it or not, I don't think takes advantage of these tools. So if I've got prosecutors, I know I've got several from St. Louis, where I'm from originally, in Kansas City, and of course down here in Southwest Missouri. I think that if you have a dialogue with your law enforcement agencies, I think you need to let them know some of these tools so that they can, I believe, even with Supreme Court of the United States case law that's coming down, as you'll see here in just a little bit, it is giving that officer in the field, when it comes to stops and searches and questioning of individuals and automobiles, great latitude. Now, when you apply the Fourth Amendment, if you will, to homes or the curtilage, I think the cases out of the Supreme Court are very, very strong that, officers, they need to get search warrants if they're going to do searches there. And so basically Terry stops, if you will, or reasonable suspicion searches, they don't comport to, homes. But when it comes to automobiles, I think you'll see that there isn't much, and they have great latitude. So let's start. Basically, when does an individual have a privacy interest? And if you go back just one slide, it's when it does a privacy interest. Yeah. The Fourth Amendment, obviously, you know what the Fourth Amendment is. But as it's applied to the general routine traffic stop, basically a routine traffic stop based on the violation of state traffic laws is a justifiable seizure under the Fourth Amendment. Now, that's very clear. A routine traffic stop. A routine traffic stop doesn't take much. Missouri law gives great latitude to law enforcement officers to stop vehicles, certainly when there is a violation of the law. And the most common one that I routinely see, your drivers are supposed to have two license plates, one on the front, one on the back. A lot of times, nicer cars don't have that plate on the front. So an officer has got a justifiable stop there in order to engage in conversation. There's a case, Grenada, that kind of spells that black and white letter rule out. Now, then there's this case where it says where a driver's actions are not prescribed by law, would not justify the issuance of warning, there is no probable cause or reasonable suspicion to stop the vehicle. Notice, no probable cause or reasonable suspicion. And you see this case that came out of the Western District. They're merging that language. And for those of you who remember for a long time, if you did DOR cases, Department of Revenue cases and DWIs, we had a long time, there's a whole line of cases where, in the criminal case, we refer to as probable cause, and in the DOR case, they didn't have that standard. And so, the language was differing, and it created this difference in case law. Then at some point, they cleaned that up, and it made, the same standard in both the DOR cases as well as the criminal cases. I'm arguing to you that this is the start of it, probably close to 2010, where the courts start recognizing using the term reasonable suspicion and probable cause in the same sentence, and it's almost interchangeable. So, but the most important rule is whether probable cause exists based upon the knowledge the police officer had prior to the search or seizure. That is a black and white letter when it comes to search and seizure law. They've got to have probable cause. So obviously, the famous Cheech and Chong, here we've got the stop. Officers at the side. Now, as I was saying, in Missouri, it doesn't take much to stop a car. Weaving within the lane, that is unusual conduct. Mulaney is the famous case. It comes out of the Southern District. I would argue to you the Southern District gives prosecutors tremendous power in the state. They have tremendous power because this Mulaney case basically says you don't even need a traffic violation to stop. Weaving within the lane is not a traffic violation. Now, out of the Western District, you are familiar with the State versus Abilene case, and then its prodigy after that, where for some reason the magic number is 3. And the 3 number is, if you touch the center line or you touch the fog line 3 times, then that, rises to the level that we can stop the car. Well, touching the fog line or touching the center line, again, is not a traffic violation. It is an unusual operation. And that gives the officer power to engage. Interestingly, Navarrete in 2014, this Supreme Court case of the United States gave law enforcement tremendous power now to stop cars. Now, what's important about that is this is a California case along the coastline. There was an anonymous tip that the person driving the car was intoxicated. So law enforcement gets in behind this vehicle and they follow the vehicle, and they follow the vehicle for a period of time, but they do not observe personally any violations of the law, any violations that would empower that particular law enforcement officer to stop the vehicle and engage the driver. At some point, they made a decision. And they made a decision to stop. Now, ironically, the person that was driving the car had not been drinking. But guess what they found in the trunk of the car? They found drugs. And based on this anonymous tip, the drug search of the vehicle was upheld. So that is very, very important. Now, I point to this last case because this is where I think there is some room to start to litigate within our state based on a difference or a conflict, if you will, between what Missouri law is versus what United States Supreme Court law is somewhat suggesting. So this State versus Lloyd case, that's a very important case, comes out of the Western District from 2010, where it says the officer witnesses traffic violation or law violation. Go to the next one. Now, this, from a defense lawyer's standpoint, is a very important case because basically there's a stop outside of Kansas City Casino where the driver failed to use a turn signal and he touched the white line dividing the case. There was a motion to suppress because the argument was, again, there was no probable cause to stop. Notice, had they stopped it on reasonable suspicion, I think you get a different result in this case. But because the officer stopped the vehicle on probable cause. Now, what's interesting about this case, the court goes to great length to spell out the failure to use the turn signal was not applicable because this was on private property. and therefore, it's not a road maintained by the government or public monies. So the officer, was in. Even though it's a mistake of law type of an argument, the Western District put it in this pigeonhole category that the officer did not, basically the officer violated the law by stopping him because there was no failure to use turn signal. Then, of course, they go to great lengths again to indicate, touch the white lines, the dividing lines. Again, that's not a violation of the law. Now, again, it might fall under Mulaney with reasonable suspicion. In fact, I would probably argue if I was the prosecutor, or that's why I'm saying if you train your officers to look for unusual operation as opposed to probable cause, I think it sets your case up in a different category. So Judge Witt, if you notice, wrote, as it defined by a municipal code, and a lot of times that's what happens in these cases. Ironically, we're using municipal ordinances to then make these laws, or that go up, the case law that comes up from the courts of appeals. It says it cannot be disputed that Lloyd was not at an intersection or roadway, and therefore he was not required to signal prior to turning. The dash cam shows the tires were touching the line but not crossing them, and that such a minor deviation does not provide police probable cause. So Lloyd, I would argue in 2010, argues this black-white line between probable cause and reasonable suspicion. And as we go through, I would tell you that I think that line has evaporated, so to speak. So one of the very important things is they cite a Supreme Court case from 2001, which the language of it is interesting because it says the court may not supply missing evidence or give the state the benefit of unreasonable inferences, basically. So now it's kind of like, does the end justify the means situation, or at least that's what is being suggested here. And so if the evidence is insufficient to sustain a conviction, a plain error affecting substantial rights is involved from which manifest injustice must have resulted, which that is a very powerful statement. But as you see, as we go through, it's going to be interesting. So when you look at factors to consider with a traffic stop, the next one. So here's what the officer is. The officer's in the situation either following, sitting, observing, okay? And so here is the situation. How does that officer get to the side of the car talking to the driver? Is there unusual operation? Is there probable cause for the stop? If the field sobriety checkpoint was proper, was there proper procedure used? Increasingly in our area down here in Southwest Missouri, the highway patrol and the sheriff's office down here, it's increasingly so because I think, as prosecutors, for whatever reason, I don't know exactly the funding of how the field sobriety checkpoints are set up, but doing saturation, doing spot checks. Highway patrol started spot checks that now I believe the sheriff's office, and I'm assuming some municipalities are starting to do spot checks. There's procedures that are less formal than there is with the field sobriety checkpoints. So here's kind of, these issues they all present when you generally look at, okay, what is the basis for the stop? How is that officer at the side? And then you go to the arrest. Now, obviously, a lot of the times in municipal cases, we're dealing with DWI cases. And so, in court, we hear the totality of the circumstances because that is what the officer uses to make the probable cause to make the arrest. And State versus Browning in 2015 lays out the NHTSA procedures and protocols. Now, I could spend 2 days lecturing about DWI cases and things like that. I only mention it because that's where a large body of law has come when it comes to the development of probable cause to make an arrest, which then ultimately leads to the seizure or the searches. So briefly, you got the roadside checkpoints. I've given you a couple case citations on that with the Sites case from 1990. That's the famous case that talks about the checkpoints and everything. But for what I'm seeing now, and we're really not doing checkpoints. It's moved to saturation. It has moved to spot checks. And so I think that, and even recently with obviously the medical marijuana law, I assume we're going to start seeing what we'll call drug checkpoints more on the interstate and some of the major thoroughways in our state, which, Phelps County is probably the leading county that's developed that drug checkpoint law in our state. So Welch, the next case is, it talks about what are the standards and the guidelines and the specifics. I don't want to dwell on that. Now, the next point I want to talk about is arrest warrants and exceptions. So this is what is known as the community caretaker. Community caretaker. There's case law that comes down, and I apologize. When I made an edit, I forgot to put the case citation back, so I'll have to get that back up. But this is kind of an interesting, what I would call community policing development. So police contacts involving automobiles occur because the officer may believe the operator has violated a criminal statute, but many more will not be of that nature. So local police officers frequently investigate vehicle accidents. There's no claim of criminal liability. Basically, it's community caretaking. Bottom line is we get a law enforcement officer at an automobile in contact with a driver or a passenger, and then the whole issue of searching is now being set up. So some of the recent developments, one of the cases from 15. So drug dogs. Southwest Missouri, we've got I-44, 71 going into Arkansas. We've got 60. It's been alleged, and I think proven over the years, we have a tremendous amount of drug activity going up and down 44, and I'm sure the same is argued in 70 up by the Kansas City area. And so the issue with Rodriguez in 15 was if a person is stopped on a traffic violation, absent reasonable suspicion, you can't keep the person there for an unreasonable period of time. But notice you start to see this absent reasonable suspicion. So the fact development that I think that would be created today is the standard, I use DWIs where you get the standard language, odor, bloodshot, slow to react to light. You know some of the standard facts that you hear in the DWI case. Well, a lot of times now what you're seeing in interactions with law enforcement in these drug cases are these what I would call Terry stops of automobiles, because that's the reasonable suspicion standard, is, the driver's nervous, one of the passengers doesn't move, they're passed out in the back, an air freshener in the car, we've got a rental agreement, but the rental agreement doesn't have the right driver on it. There's some facts that I think, which I would argue to you, given the leeway that the Supreme Court is deferring to law enforcement out there in the field, all you've got to do is develop those facts that would rise to the level of reasonable suspicion, which then might get you to a credible search and seizure and, commentary. So, again, the Navarrete case, I think it's kind of an interesting case to read, because I think it's one of Scalia, I think, dissented in that, and the argument that he made was typical Scalia, defiant. But the argument that he was making in it is that what if you've got a person that says, they call 911 or they call somebody and they just say, hey, there's a car driving on such and such street, and it's a setup deal. It's not really drunk driving or anything like that. The difference in Navarrete is now officers, without witnessing anything, can stop the vehicle. That's powerful. They don't have to observe either reasonable suspicion, they don't have probable cause. Just based on a tip, they stop the car, and then they can do business. They can have contact. So I think that's very, very important. Now, this next case I want to spend a few minutes on, because I think it's probably one of the most powerful tools that law enforcement has today. This High-End case from North Carolina in 2014. Basically, it brings good faith exception to searches and stops of vehicles. And what I mean by that is that, as you know, under search warrants, we have the whole line of cases that came out from Leon that says, you know, if they made mistakes, if they just didn't put the right stuff in the four corners of the document, we're going to let law enforcement have a good faith exception. Well, guess what? High-End, just 4 to 5 years ago, does that for law enforcement now with traffic stops. That is a very, very important case that not only you should read as a prosecutor, but you should get it to your law enforcement officer. Now what's important in High-End? In High-End, what's important about that is a law enforcement officer made a stop based on a municipal ordinance violation that the license plate light, one of them was out. Actually, this car had 2 lights, but one was out. And believe it or not, the ordinance did not delineate if it had to have 1 light or 2 lights. It just said you had to have, it just had to say, it basically said you had a light. So the officer stopped the vehicle, and then ultimately there's a search, and of course there's something bad. But in this particular case, they were trying to say that there was a violation of the Fourth Amendment, and therefore that search and the fruits, so to speak, should be suppressed, and the motion to suppress should be sustained. Because what happened was there was a mistake of law. The law enforcement officer he misread the law and misunderstood the law. And basically, he didn't have a valid reason to stop the car. The license plate was illuminated. It just had 2. And so even though it had 1 light working, the fact that the second one wasn't working, still the driver of the vehicle or the vehicle itself was valid under the North Carolina law. Now, ultimately, in this long opinion, so it's a pretty good opinion, Justice Roberts writes it, and I believe Justice Sotomayor wrote the dissent in it. And Justice Roberts goes to great lengths talking about mistake of law and how we, going back, and I think he cites cases going back to 1809, going back to 1809, that once, if there's a mistake and there's interaction at that point, that's okay. That's okay, because it's the next step, the next prong, if you will, where they're taking a look at. So what the court does in this High-End case is an excellent thing that talks about the 2 concepts. You've got obviously the understanding of law, and here this particular case, the officer made a mistake. But then they focus on the second aspect. They focus on the observations that the officer made. And when I was talking earlier that the driver was nervous, there was some other facts that raised his suspicion level to ultimately get access to search the vehicle. And of course, there was contraband in the vehicle. So what's interesting on this is there were several cases that they cited in it that previous precedent Supreme Court cases going back. Now, obviously, Judge Roberts cites one line of authority that sustains mistake of law is okay, because he focuses on reasonable suspicion and he focuses on objectivity. Objectivity. And what I mean by that is they actually get into a dialogue where they're articulating that since the officers in the field, the officers having to process this, the officers having to make these decisions, it's the officer's interpretation of the scene, which you all know, giving a law enforcement officer in the scene authority to process what he's doing or she's doing gives them great leeway. And basically, we're now analyzing if what the officer's actions, ultimately here the search and the seizure, we're obviously analyzing was what the officer observed, does it rise to the level of reasonableness, objective reasonableness, so that the officer could justify the search and then justify the seizure. What's also interesting is the two lines of cases when anytime it comes to search and seizure, you've got the first issue, which is the Fourth Amendment. Was there probable cause or no probable cause? And then you got the second issue. You got the exclusionary rule. In this particular case, the officer was wrong. He interpreted the law wrong, and because he interpreted it, it's perceived that there's no punishment for him. No punishment. He stopped this car. He was wrong on the law, but that's okay because we're going to focus on this reasonable suspicion standard. And so I would suggest to you that this is the first time in 14 where they start to look at reasonableness issue. Now, there was a case that just came down, the next case, which again reinforces this concept that the Fourth Amendment is alive and well when it comes to the home and the curtilage. And in this particular case, Collins v. Virginia, if I remember correctly, there was a motorcycle that was stolen, or there was some basically missing motorcycles. The law enforcement officer was sophisticated enough to check Facebook, and he saw some images there that raised his suspicion. So this law enforcement officer actually goes to the house, trespasses on the defendant's property, goes up, lifts up a tarp, sees the stolen vehicle, then goes back to his car and waits for the person to get home, then confronts. The court in this particular situation said, hey, these items were within the home's curtilage. This search was improper and actually suppressed, and said this was an invasion of the curtilage. This was just last year. So again, they write this language in this Collins v. Virginia case, which seems to say, hey, while the officer had probable cause to believe the motorcycle might be there, what the officer should have done was go get a search warrant, because it was at a home, it was in the curtilage, but, or develop the facts in order to get that search warrant. But what the officer did here was he trespassed, he actually lifted up the tarp and then gained knowledge and then waited, and then ultimately the court in this particular case just that last year said that's unacceptable and we can't do stuff like that. Now, there is another case from 2018, which is also fascinating, because I'm trying to rectify this particular case with Missouri law. So interestingly, the Byrd versus U.S. case that came down about a year ago had to do with a rental car situation where somebody rented the car that wasn't driving the car. Basically, a third party was driving it. And in this particular case, the law enforcement officer made a stop of the car. Now, the issue that went up to the Supreme Court was, does the driver of the car, quote, have a reasonable expectation of privacy? And ironically, they said he did. They said that he had standing, even though because what happened here ultimately was because the driver of the car's name wasn't on the rental car agreement. If I remember correctly, it was kind of clever. The officer testified that because the driver's hands were at 10 and 2 on the steering wheel, that was suspicious. I didn't know that was suspicious to have your hands at 10 and 2. And they also argued that I think in this particular case, there was a person in the back sleeping that didn't move when the officer stopped the car. And then their name wasn't on the rental agreement. And so ultimately there was a search and they found, I can't remember if it was heroin or marijuana, obviously contraband. What's interesting is that, again, this issue that went up to the Supreme Court was not did the officer have reasonable suspicion to go search the car. It went a different way. It went, did the driver of the car have a reasonable expectation of privacy? And it focused all on this rental agreement. So this is kind of where it's an interesting argument as they, in my humble opinion, create more conflict, because in one way, in the previous cases, they basically say, you know, drivers don't really have any Fourth Amendment rights in a car. And then all of a sudden they come out with this Byrd case in 18 that says, well, the driver's got a reasonable expectation of privacy when it comes to this, you know, operation of a motor vehicle. Now, what they did do is I think they did send it back. It's a deal where I think the person ended up pleading guilty and then, you know, preserved the right to appeal on the suppression issue. Court says that, you know, a person has a reasonable expectation of privacy as the driver, and I think they've remanded it for further proceedings. So now I think the case is going to go, because I think the issue was, did the person have standing to be operating that motor vehicle, the rental car that is, if their name was not on the rental agreement. So I think that's one of the issues. Now it's going to go back and focus on the reasonable suspicion side of it. All right, so obviously we've talked a little bit about stops or access, if you will, to give law enforcement a legitimate reason to come in contact with the driver of that car. And I would tell you that I think that there's a lot, especially under that Mulaney case, especially under Navarrete, especially under Hyen. You know, those tools are very, very important. One other comment I wanted to make on that Hyen case, because Sotomayor wrote the dissent in it. And so she lays out this argument. Now we're going into basically, you know, what's objective and what's not reasonable, and what should the objective reasonable officer, you know, again, going back to DWI law, you know, what would the reasonably prudent law enforcement officer do? Kind of a test or standard. And, you know, as you know, the Supreme Court is very good at giving us, quote, balancing tests to take a look at things and not necessarily guide us to reach a conclusion, but just give us, these are some benchmarks, if you will. This is what we're looking at. Well, that Hyen case made it crystal clear that even if there's a mistake in law, and in fact, one of the points that was argued by the defendant in this particular case was ignorance of the law is no excuse. We hear that all the time to give law enforcement, you know, people, I didn't know that was the law. Well, the ignorance of the law is no excuse. The argument was actually made, well, because the officer didn't know the law, and it, you know, that doesn't apply to him. And they kind of got into a discussion of immunity or qualified immunity, and there's no civil action here. And so all of a sudden they're getting into this area where they're talking about reasonableness. Well, here we go. We're going to get a whole line of cases where courts are saying this is reasonable, but this isn't reasonable. Which, bottom line is, I have yet to see a case that actually comes down where it says, you know, if you got fact 1, fact 2, fact 3, that's going to meet the criteria of reasonableness. Because didn't we go through that with DWI law? And, you know, and now we've kind of gone back to, you know, with the Browning case and the standards. For those of you who've tried a lot of DWI cases, you know, we went through a phase there. Well, the officer did his best on the HGN test. He might not have followed it totally, but it goes more to a weight argument as opposed to admissibility argument. I think we're going to start getting what are reasonably prudent law enforcement officers supposed to think. And so Sotomayor in that case goes into great discussion about how that's dangerous. All right, so here we are suppressing pre-Miranda statements. Pre-Miranda. Now, I don't know about some of your jurisdictions, but there must have been a seminar in the last year, because I've had an increasing number of clients come in where they say law enforcement, when they make the stop, they put them in handcuffs, but they tell them you're not under arrest. And then they proceed talking to them. So it's an issue of what is custody. And then Missouri lays out this case, basically taking the Eighth Circuit case, United States versus Griffin, where it lays out these 6, what I would call benchmarks, or 6 categories, if you will, where a person might think that they're in custody. Well, so if prong 1 is met, a person is not free to leave, or they're in custody, then we go to prong 2. Prong 2 is the question incriminating or is it investigatory? And lately, what you're starting to see is, again, a categorization of questions that law enforcement might ask an individual, such as, how much have you had to drink? Now, I've found some jurisdictions to say, well, that might be incriminatory, and I've seen other jurisdictions where that's investigatory. Tomato, tomato, potato, potato. So I think that's kind of interesting, but this kind of gives you the feel. Lots of times law enforcement officers think that if they utter the magic words, you're not in custody, that seems to alleviate that first prong. I would tend to think, I think many of you prosecutors know that's not the case. But for some reason, that's being taught somewhere. And what I think needs to be taught is basically what the courts are saying in the Eighth Circuit. And of course, as prosecutors, the Eighth Circuit in the country is probably the best circuit to be as far as law enforcement, and because the decisions that come out of the Eighth Circuit continue to empower law enforcement. So let's go with now the search of a vehicle. So we've got protective sweeps, we've got probable cause, and then of course the other category is consent. So let's take protective sweeps. Increasingly in Missouri, so now people can carry basically weapons in their car. This is one tool that law enforcement officers can use. Protective sweep. Question is, I see oftentimes is once they remove the person from the car, whether it's on the side of the road, take them back to their vehicle, do they have the ability then to go back to the car and do a protective sweep if the rise for protection has now been removed? So we've kind of seen that situation. And that's creeping up, obviously, with, there's the weapons laws in our state continue to be expanded, where I think it's reasonable now with all of the exclusion zones, if you will, schools, arenas, things like that. I think I would argue to you that people are driving on those properties not realizing that, well, I'm sure they know they got a gun in their car, but I'm sure they're not realizing, hey, you're not supposed to have a gun in your car in a school zone, for instance. So, there's a can of worms there, I think, that's eventually going to have to be addressed. Probable cause. Notice there's no reasonable suspicion standard now to give access. It's probable cause. Does the officer have probable cause? The reach area. Now, the $50 million question is, okay, if marijuana or roaches or things like that, is the odor of marijuana emanating from a car enough to search because of the medical marijuana law now in our area or in our state? I would tend to think that that's going to be an interesting development of the law, because especially being in a college town where we got 30, 40,000 college kids, it's going to be interesting because I'm usually seeing, I was sitting 2 car lengths behind and I could see smoke emanating from a car, and it was that of marijuana. And that is the sole basis for the stop. So it's going to be interesting. I would tend to think that, we've got a conflict in law between federal law, municipal law, state law. It's going to be real interesting on that. So it depends on how aggressive you want your law enforcement officers to be. I can tell you that in my jurisdiction here in Southwest Missouri, they're not as benevolent as that of Jackson County. I wish they would be, but they're not. So, they tend to be more law enforcement oriented down here, which is going to be, I think, eventually the case is going to come out of the Southern District, which then will, get its way to the Supreme Court. The last category is consent. Consent is all over the place, voluntariness of the consent. If the office, so a lot of times we have a situation where the officer just tells the driver, hey, I don't need a warrant, but, and I'm going to search anyway. Or they haul them back to their car. And now the question is the consent voluntary? Now I realize we're dealing largely, or mainly, if you will, college kids that, they got a roach clip in the car, and do they want to turn it into a federal U.S. Supreme Court case on whether or not they obtain voluntary consent? It's the principle or the practicality, if you will, of it. The other situation, you got multiple people in the car, and the officer gets permission from a passenger, not the operator of the motor vehicle, that situation. And then you got the apparent authority situation. So you've got these situations which, depending on the gray area of how far the officer wants to push it there, it starts to get a little complicated. And in the scenario, typically, is the driver or the passenger or both, everybody is removed from the car. Now we're confronted with probable cause issues. Where does the probable cause give him access to the trunk? Does it give him access to the bag in the trunk? Does it give him access to the bag that's in the bag that's in the bag that's in the trunk? And so you start to get these scenarios. Obviously, you got the cell phone search that came down, Riley versus California, basically under a search incident to arrest. It doesn't give the officer a right to get into the phone. So that kind of lays out some of the measuring balance or the balance test issues. Interest in protecting officer safety did not justify dispensing with warrant requirement or the warrantless search before officers could search a digital phone. So typically, a lot of times, officers use, again, the protective sweep or officer safety. Again, they're taking the person out of the vehicle and then they're going back to it. There's an argument now, how is the officer in danger at that point? At least I'd argue that. Why, now that the person's removed, whether or not they can access a glove compartment, there's a gun in there, rises to that level of is that a valid search? Then the famous one that I think that's developing, in the backpack, you got a book, and in the book, there are pages with drug notes. Does a search incident to arrest scenario give the officer permission to go in and search that bag, search the book, open the book up, look at the book? So, those are real scenarios. This Salinas versus Texas case that came down in 2013 created a very unique situation. The Miranda rights, you have the right to remain silent. And if a person remains silent, that can't be used against them. But what about the scenario where the person is not in a custodial situation, non-custodial? The officer does a knock and talk. The officer just asks a question. And there's silence. Believe it or not, in that situation, this was a murder case where the officer asked the individual, did you murder so-and-so? And the person just sat there silent. Now, The argument is, if you didn't murder somebody, you're going to speak up and say, hell no, I don't know what you're talking about. I didn't murder that person. Well, in this particular case, the person basically invoked their rights, even though they weren't given their rights. And the officer and the prosecutor ultimately used the silence argument as basically a sign of guilt, or a sign, if you will, a fact that came in as evidence. And then an argument was made that, basically the person was silent. And if they didn't commit this crime, why would they remain silent? So it's kind of an interesting situation. And then also the one thing I find fascinating, even though, you've been practicing law for a number of years, is going back and looking at the logic that they use to, in this particular case, use pre-custodial or non-custodial situation to basically, it's a free-for-all. Law enforcement does not take advantage of that non-custodial situation. And so what I mean by that is the typical situation at the side of the vehicle. And when I lecture to law enforcement, why doesn't law enforcement just ask the driver, are you drunk tonight in a DWI situation? Impaired, drunk. I think it's cute and clever where they get, how many drinks have you had? And you get the standard 2. Or you could get sophisticated on a scale of 1 to 10, 10 being drunk, 1 not so drunk. Where are you? You guys know, as prosecutors, our clients like to talk. It's the ones that talk that get in a lot of trouble. It's the ones that don't talk that get, that makes it more difficult for you. So, the Fifth Amendment does not prohibit the prosecutors from commenting on defendant's silence in response to non-custodial police questioning. Use it. Train your officers to take advantage of that, because they're not in custody at the side of the road yet. So, and if you got a willing participant, have them talk. And most of our officers now are mic'd up, dash cams. You get all sorts of good stuff. It makes your job a lot easier. So what I would tell you, the inventory searches. Inventory searches, truthfully, it's just like getting a search warrant to go search a house. For some reason, that's the easiest thing to do. But we got a lot of knock and talks going on lately as opposed to getting the search warrant. I know it's time consuming. I know it's, crosses T's and dots the I, but as well as I do, that case law that's out there, if a law enforcement officer gets a search warrant, it's all but, it's a gold seal delivered to you. I would argue to you, having a law enforcement inventory search policy is the best way to get into that car. Seize the car. You got access to everything. Make sure it's all written out. You've got 2 types of inventory searches. Probable cause, where the car is impounded to preserve as evidence. Now, granted, I know that's time consuming and all of that, but if your officers are looking to make a drug bust, and we're not talking about, a gram or 2, we're talking about pounds. This is the best way to get yourselves all protection for your officers if they've got a clear inventory search policy where everything is spelled out, it's all accounted for. 2012, the State v. Williams lays that policy out and basically blesses it. So I think that's very, very important. You all know the famous search incident to arrest case, Arizona versus Gant, back in 2009. It gives law enforcement officers tremendous opportunity to search. Where it starts to get complicated, if a person's in the driver's seat, the search incident to arrest give them access to go back to the back of the car. So, familiarize them with Gant, I think, is very, very important. And that Hyam case, the Navarrete case, those 3 Supreme Court cases of the United States, I would argue to you, in a way, overturns what Lloyd set up. I really think that. I think that, Lloyd's older. It talks about a probable cause standard. And reasonable suspicion, mistake of law, observations of law enforcement officer, basically those cases have eroded the Fourth Amendment when it comes to automobiles. And most importantly, I think that it has been clear that they say they're not going to go to the exclusionary rule. Even if the officers are wrong, they're going to give them that good faith exception to automobile searches. So lastly, and of course it's more probably for the defense side on a motion to suppress, it must be in writing. Now, every once in a while, issues have come up in trial. You don't know there's a suppression issue. The officer will say something, but it's got to be, it's got to be in writing. And, for depending on what your jurisdictions are, most of them take the motion to suppress issue with the trial. Obviously, if you've got some jurisdictions bifurcate that. Our particular prosecutor's office does not like, here in Greene County, not the city, but the state, they like to have those bifurcated for some reason. And I think that they don't like to have in the motion to suppress issue with the trial, so a lot of times we have them separate. And I gave just basically a standard language, suppress physical evidence, that kind of thing. It talks general. And then sometimes on a particular case, we'll orientate the court on what is the specific issue, if you want to go back. Thank you for your time. I've got a few minutes. I hope that was interesting. I'll be glad to answer any questions.
Well, no questions came through during the presentation, but we can give them a couple minutes to type something if they got something they want to ask.
They left.
What's that?
Maybe they all left. I lost them.
Maybe.
Well, thank you very much. And if there's any time, the law, I think these are fascinating cases if you actually look at them, but especially the Supreme Court, the Eighth Circuit has a line of cases. I cited some in the PowerPoint. Please let me know if you've got any questions or any issues. I'm glad to help.
Well, thank you so much for joining us this afternoon, Joe, and taking time out of your day. I appreciate that. And if I get any questions that come to me for some reason, I will forward those on to you guys as well. So I think still no questions came in, so we'll go ahead and end. And if anybody has any feedback about today's webinar, you can email me or call me here at the office. That'd be great. Thank you.
Thank you very much, Miss Emily.